Well, you know, it's great to be back at the Crossroads of the West gun show. I can't even remember the last time I did a talk here. We had this little issue called coronavirus that's slowed things down a little bit, but it's good to see people back. And I like it when we do the show outside because people are just roaming by, and we get a lot of people coming over, but we're kind of off to the side a little bit now. So we'll see if people wander in. If you guys have heard my talk before, it's kind of an unstructured talk. I go over some things that are important to know about really just criminal defense generally, but especially gun cases. By way of background, I've been practicing now pushing 30 years on criminal defense. I can't believe it's gone by so fast, but represented thousands of people in major felony cases now, many of them in Arizona, but not all of them. A lot of them in state court, a lot of them in federal court, and I've done lots of cases across the country. We also do trial level and appellate level. You'd be very hard-pressed to find an attorney who has a more diverse amount of sort of experience. So I've been around the justice system, and I've been a student of the justice system the whole time. My undergraduate degree is justice studies. So I have a lot to say about the justice system, and I'm a big fan of improving it. So let me tell you, first, our law firm is the Attorneys for Freedom law firm, and we represent people in all criminal cases, in all courts, at all levels. We also do civil litigation and personal injury and some civil rights. So I like to tell people that we go after bad cops. We also protect good cops because I don't believe in generalizing groups of people. There's good and there's bad in every single group. So let me tell you why Roger's here. Roger's actually, I first introduced him as a good friend of mine, Roger Nosker. He's a guy who I've gotten to know, wonderful person, and really honored to count him among my friends. But he's going to come up and talk a little bit about attorneys on retainer and how he wishes he was part of the Attorneys on Retainer program. Let me just tell you about it really fast. Attorneys on Retainer is our discount legal plan. And you can't sign up after you have a problem, kind of like insurance, right? If the house is on fire, it's too late to get the fire insurance. Same thing with Attorneys on Retainer. But if you sign up, and it'll cost you an entire $100 to sign up, and then $25 a month. We got a couple of different plans for people here in Arizona. The same is true for people in Hawaii because we have offices both in Arizona and in Hawaii. First, and most relevant for this crowd here, the gun crowd, and nobody speaks more to the gun crowd than me. I've been speaking at the Crossroads of the West gun show for now, I don't know, 20 years or so. I already know the questions you guys are going to ask. But we have this self-protection program. It's $25 a month, $25 a month. And if you're enrolled in that program and you get into a problem, or said another way, charged with a crime, misdemeanor or felony, involving you using your firearm, and you can say, hey, I was acting in self-defense, I was acting properly. You just tell us that, and you're covered. 100% of the legal fees. You get our law firm, the Attorneys for Freedom. We're going to represent you exactly the same way if you were paying my $650 an hour rate. Same exact representation through trial, all the way through trial. Imagine what that would save you. Could save you really $100,000 or more. It's not inexpensive to try a case. So that's the self-protection option. Then we have another plan, which we call the standard option, I think we're calling it now. The standard option is really simple. If you get charged with anything, then you're covered. Anything, anywhere, in terms of a criminal offense, you are covered. So not just gun cases. It covers you for DUIs, covers you for any kind of domestic violence or theft or whatever kind of disorderly conduct. You get charged with anything, then you pay a reduced hourly rate of $175 an hour, less than I was charging when I was a brand spanking new lawyer. Also, if you get sued, this is one of the fastest ways you can get into a financial problem, right? We all know there are really two ways you can have a financial catastrophe. One is a health problem. That's why you have medical insurance, because that stuff adds up fast. The other is a legal problem. Anybody can sue you anytime for pretty much anything. If you're part of our standard option, then you get defense from our law firm at $175 an hour. So if you're charged with anything or sued for anything, you're covered at $175 an hour. You also get discounts on personal injury cases. So if you are unfortunate enough to get involved in some kind of an accident, if you get sued for causing a personal injury, $175 an hour. If you're a victim of somebody else's negligence, you get a discount on the contingency rate. That's also $25 a month. But if you want both of them, it's $40 instead of $50. We call that the bundled option. So I don't know what Roger's going to say. I don't know if Roger knows what Roger's going to say, but I'm going to have him come up here and just talk a little bit about his experience with our law firm and really anything else he wants to say. Really honored to introduce Roger Nosker. Thanks, brother.
Hey, good morning. I'm glad to be here. I never thought in my life I would need a lawyer. Most of us try and go through life not being involved in legal matters and court hearings. In this day and age, though, I'm afraid that's somewhat naive. Just like health insurance, home insurance, you really need to guard your future. I wish I had been a member of Attorneys on Retainer at the time I was charged. And unfortunately, I found out somewhat later, after charge, one of my very good friends, co-worker, actually is Attorneys on Retainer with Attorneys for Freedom. I can assure you, after what I went through, I was attacked and assaulted in the presence of my wife. I was charged with a felony that was a mandatory 5 years in prison and possibly as much as 15 years. I was defending myself. I went through 3 different attorneys in Flagstaff. That's the community I'm from. 3 different attorneys. They were either had no intention or didn't have the time or the attention to give my case. I even had one attorney recommend that I lie on the stand, and I wouldn't do that. And the third attorney just really didn't appear to be competent. So 3 attorneys, I'm charged with a major felony. I'm looking at losing my entire life. And through a family member, I was directed to Marc and Andy and Attorneys for Freedom. They did take my case. I can tell you the defense I received was incredibly competent. It was very, very thorough. I'd love to be able to make lawyer jokes, but I really can't because I found AAFF to be incredibly credible, showed me a great deal of dignity, were very good about their communications, and probably one of the things I really like about the firm, and not just Marc, but it's very much a team approach. When I contacted that office for anything, I always got an answer. I always got somebody to talk to me. I always got some kind of follow-through. That was not the experience I had with the 3 previous attorneys. You do need to protect yourself. You need to guard yourself. You need to take care of your future. I would tell you that with the anti-gun sentiment that tends to be very pervasive now, I'm not even sure the Second Amendment in terms of defending yourself exists, at least in my experience in Flagstaff. I was defending myself from an assault from a guy with road rage, and I almost ended up in prison for 15 years because of that. So it can happen to you. I've never had a criminal conviction, never had any kind of a criminal offense. I tend to be a social worker type, not someone that even normally carries a gun. But for full disclosure, and after recommending AAF and their Attorneys on Retainer program, I am part of a multinational criminal enterprise. It's important for you to know that. I actually robbed the train, if you've ever been on it, from Williams to the Grand Canyon. I'm a cowboy. I rob the train 364 days a year, so I do rob people from countries all over the earth. But other than that, I've never been involved in any kind of crime. I really want to recommend these guys. The level of integrity and competency I saw was really amazing. And anymore, and I'd probably start repeating myself. So I just appreciate you guys a lot. I could recommend you really look into this.
Thanks, brother, for sharing that. You know, it's funny because a lot of people who don't know what criminal defense is about sometimes will ask me, hey, Mark, how can you represent these kinds of people? And I say, pretty easily. I've made a lot of good friends representing people over 27 years. And this is a shame because I shouldn't meet good people charged with felony offenses. These should be rotten, horrible people. But it's not the situation right now. And part of this is because we have a lot of stupid crimes, things that shouldn't be crimes. So good people get charged with crazy crimes for doing, in my opinion, absolutely nothing wrong. Also, good people get charged for serious crimes when they didn't commit them. That happens as well. And so it was a real honor and pleasure representing Roger Nosker. And thanks so much for that, that unpaid endorsement, by the way. So let me say, here's what I'm going to talk about. The 5 most important things you need to know. The stuff that I've figured out. It's not in any book other than maybe the pamphlet that I wrote called The 5 Most Important Things Every Responsible Gun Owner Needs to Know. Other than that book, it's not in any book. This is the stuff that you need to hear from a criminal defense lawyer who's been in the trenches for 27 years. I'm in court all the time. Not one of these guys that's sort of the figurehead of the law firm that you see only on the billboard or in the commercial. I'm one of the guys that goes to court. I was in court this week on a big, major knockdown, drag-out kind of hearing. I can't tell you how awesome it was to stand there and have the judge hold up a piece of paper and say to my client, here's the piece of paper that I got filled out. I was going to send you to prison today, but I had my mind changed after a long hearing we had in court. I can't tell you what it felt like to see that family crying back there in the courtroom because they know that a dad, a husband, was not going to prison, and he shouldn't have gone to prison. It was the right result. But I'm just saying there's nothing like that feeling when you can save somebody from going to prison. So I'm going to talk about the 5 most important things you need to know. Depends on how much time we have, how quickly we go. I got lots of material. I can talk to you probably for the next 24 hours straight. But I may talk to you a little bit about self-defense, deadly physical force, ARS 13411, one of my favorite crazy statutes, the self-protection or the crime prevention statute 13411, and also some about defensive display, an issue that came up in Mr. Nosker's case. Roger, we talked about this and argued about this. It's a crazy little statute, and what it means nobody exactly knows, but I'll tell you what it says and what I think it means. So let me start with the number 1 most important thing you need to know. Just shut up. I know you think you can tell this cop things. I know you think you got things you can say. I know you think that, well, I'm not really guilty of anything, so what could it hurt to say? Let me tell you, I could bring Roger back up here again to tell you how you said it, the way you said it, when you said it. Why did he say this? Why didn't you say that? How come you forgot this? They will pick apart every little piece of the statement that you make, no matter how reasonable, no matter how comprehensive. They will pick 2 years after it happens. They will go through and ask you a million questions. And by the way, if you guys got questions, just put up your hand. We'll make it interactive. This is why just don't say anything. Okay, I got a deal worked out with the cops I want to tell you about all across the nation. We've made an agreement. The cops have agreed to remind you of my most important, number 1 most important piece of advice for you to remember. Just at the right time for you to hear it. They're going to tell you, you got a right to remain silent. If you hear that, you should remember that very short but very handsome lawyer, Marc Victor, from the Attorneys for Freedom law firm. Remember that advice. He's telling you, hey, Think of him tapping you on the shoulder when he says you got a right to remain silent. And actually, what this means is, don't forget about Marc's advice to just shut up. But just in case this isn't enough for you, because, you know, it's traumatic, maybe you've been through a shooting, something's going on, you're being arrested, this cop is going to tell you more than you have a right to remain silent. This cop is going to tell you something critically important. Anything you say will be used. Does anybody know how it's going to be used? Anybody know? Hands, show of hands. How's against you? Think about what this means. Anything you say will be used against you. And I would like them to say, anything you say in some stuff you maybe didn't even say will still be used against you. Because if that statement is not recorded, if it's not, a body cam's not on, they can say you said anything. I've seen this before, many occasions. You know how many times my client has told me, hey Mark, I know it says this in the police report that I said X, Y, and Z, but I'm here to tell you I never said any such thing. I got lots of stories about stuff like that I could tell you about. They'll also tell you you have a right to an attorney, just not right now. You're not getting one right here, but you have a right to one. And if you can't afford one, one will be given to you for free. You probably won't want that lawyer, but to be fair, there are some very good public defenders. They're just so damn busy. They have so many cases, it's hard to spend time on your case when you're working on too many cases. So if you ever hear that, think of that as Marc's reminder to just shut up. Now, I wish I could stop there and move on to number 2. And maybe the really young, brand new lawyer, Marc Victor, 27 years ago would stop. But I know better than that, because I know you guys aren't listening to me. I know you're still going to talk. I know that because I've been speaking at this gun show for many years. And people, when they come in on cases, I say, how did you hear about me? And sometimes they say, oh, the gun show. I say, oh, did you hear my talk? They say, yes. And then I say, well, certainly you didn't talk to the cops, right? And then they look down. I say, you kidding me? You still talk to the cops? So I pause a little bit on this point, because you've got to understand why. There's reasons why. You don't understand how the game is played. The fact that you're silent, this can't be used against you. I know you might be thinking, well, if I don't say anything, he's going to think I'm guilty. Maybe they'll arrest me. What would a jury think if this went to trial, that I didn't make any statements? None of that's going to happen. The fact that you remain silent is not a reason for you to be arrested. They might still arrest you if they got other reasons, but it's not going to say in the police report, I arrested him because he failed to make a statement. That's not going to be in there. It's also not going to be part of the evidence against you when they seek an indictment, because it doesn't provide any evidence, nor is a jury going to hear about it if you go to trial. How's that going to play? The way it's going to play is the cop's going to be on the stand and the prosecutor's going to be taking that cop through what happened, and they're going to go right past it. The prosecutor is not even going to ask the question, did you ask the defendant if he or she had anything to say? And I'm just going to say he from now on, because it's almost always guys. That's who we represent, mostly guys. I don't know. Women don't commit as many crimes as men. That's just a fact of life. So cheers to the women on that. But if they do comment on your right to remain silent, and this happens occasionally, you get a brand new prosecutor or you get a brand new cop, and one of them lets squeak out on the stand in front of the jury, yeah, you know, I asked him if he had anything to say, and he said, you know, I got nothing to say, I'll wait for my lawyer, something like that. Well, if your defense attorney is not asleep at the switch, your defense attorney is going to stand up and say, excuse me, Judge, may we approach? Anybody ever wonder what happens during those little sidebars? I can tell you what happens in this situation. The defense attorney says to the judge, hey, Judge, that cop just commented on my client's constitutional right to remain silent. I want a mistrial. And the judge is going to look at the prosecutor and say, I heard it too. And the prosecutor is going to squirm around and say, well, you know, I don't know if the jury heard it or he meant something else or it was an accident or something like that. And hey, Judge, just give them an instruction that says they should just disregard what was said. So the judge has options at this point. Option number one, just tell the jury, you know, that thing you heard a few minutes ago, forget that. We lawyers call that unringing the bell. You can't unring the bell. So the defense attorney will always say, Judge, that isn't going to work. They already heard it. They already know, and now they're going to hold it against my guy. My guy's not getting a fair trial now because he got a right to remain silent, and the prosecutor and the cop just put this information out there in front of the jury for them to hold against my client. We got to start over. I want a mistrial. And if it's been pretty clear what was said, you're going to get probably a mistrial. The big question is going to be, is it going to be a dismissal with prejudice or without prejudice? Will they start again? So we'll see. If it was done intentionally, maybe the prosecutor asked the question to the cop, did you ask the defendant if he had anything to say? That's an intentional problem. That might be a dismissal with prejudice, case over. But if the prosecutor just said something, what happened next, and something like that, and the cop blurted out, well, I asked him, tell me what happened, and he said, I want my lawyer or something, maybe not. You might start with a new jury. But this is always a good win for the defense attorney anyway. Some of us are known to be professional pains in the ass as we're trying a case. Because you know what? The state's trying to convict our client, and there's nothing wrong with that. Make and improve the case. Also, something that you probably didn't think of. You didn't think of this, maybe because you were listening to the advice of people who are happy to give you advice on what to say, who aren't lawyers, or who are lawyers, but they don't do criminal cases. Just because somebody's a lawyer doesn't mean they know anything about the criminal case. They tell you things like, well, if you're involved in a shooting, always say, I was in fear for my life, and don't say anything else. And some of them say, well, even ask for a drink of water or something like that, whatever. I do not think you should say that. I know why people think you should say that, because being in fear for your life can be a good justification for shooting somebody. But it's not the only justification for shooting somebody. Once you say that, you have now limited your defense lawyer to that theory of the case. We're stuck with the defense now that the defendant shot this person because the defendant was in fear for his life, which might be a good defense. But what happens when defendant shot dude in the back? That's not going to be such a good defense anymore. Might have had a good defense. How about I shot because I was in fear that he was going to take someone else's life? You can shoot a person for that reason. There's also other justifications. There's that crime prevention, 13411, that I told you about. This involves a different kind of a mindset. I shot because I was stopping them from committing one of the crimes on the list in 13411. That might have been a good defense, but because you opened up your big mouth and followed the advice of somebody who probably doesn't do criminal cases, you said, I shot because I was in fear for my life, and now we're stuck with that. So don't do that. Don't limit your legal theories. Also, at the time the cop is asking you for a statement, that's the worst possible time to be making a statement. Why? Because I know you're stressed. Even if you don't look stressed, you're definitely stressed. Something just happened that requires the cops to show up and arrest you. And you're wondering about lots of things. Am I going to jail? How long will I be in jail? What bond will I get? How's this going to affect my life going forward? I'm supposed to be at such and such place tonight, tomorrow, the next day. How much is it going to cost to get a lawyer? Am I a member of the Attorneys on Retainer plan? Did I get the self-protection program so now my attorney's fees are covered? Or did I just decide to wing it? I have an extra $100,000 sitting around to pay my lawyer to defend me on this case. You got those kinds of things going through your head at that time. And if you get something wrong, which you might, because you're stressed at that period of time, they're going to play that video, if they got it, or that audio over and over and over again in court. Terrible time to be making a statement. What if that cop writes something down wrong? I've had this happen on occasion too. Well, where'd he come in? He came in over there. Maybe you're pointing to the door. They think you're pointing to the window, or vice versa. They write down, he said that the bad guy came through the window. That's not exactly what you said. It might have been what you meant. You might have meant something else. Do you really want to risk 10, 20 years of your life on whether that cop writes down correctly what it is you said, if it's not being recorded? And if it is being recorded, sometimes those recorders turn off and turn back on. Not everything's on the recording sometime. You really want to trust decades of your life? And what about if the cop's a liar? Yep, I just said it. Some cops are liars. Some cops are criminals. I want to be clear on this. Most of them aren't. I don't know what you think about cops, but I've dealt with lots of them over many years. Most of them are good people trying to do the right thing. Some of them are thugs. Some of them are horrible thug kind of people who join because they like bossing people around, pushing people around, punching people. I don't know what the percentage is, but those cops are out there. You don't know, if you don't know this cop, and you probably don't, why would you trust your freedom to the honesty of somebody who you don't know, or lack thereof in terms of honesty? Just because they're wearing a badge? Are you that naive? Just because someone's got a badge affixed to a fancy uniform, they're honorable? I can assure you that is not the case. Okay, now that hopefully I've convinced you to just shut up, or at least given you some good reasons, I'm going to tell you, forget all that. There's 5 times when I think you can throw that out the window. 1, the dreaded 911 call. There are books written about this. In fact, I was consulted on one of them. Alan Corwin, who you may know, did a book on calling 911 after a shooting. And I was one of the lawyers that he so desperately tried to get to create a controversy here about things. What to say, should the lawyer go to the scene, all these other things. No. I don't want you saying much of anything. But if you don't call 911, it might look bad for you. It might look like you were wanting this person to die. So what's the best answer here? Get someone else to call 911 if you can. You shouldn't make the statement. What is it we're trying to communicate to 911? Hey, 911, there's been a shooting. Please send an ambulance. Here's the address. Bye-bye. That's it. And make that call before you call your lawyer. Because what is admissible is not what you said to the lawyer, what the lawyer said to you, but the fact that you called the lawyer before you called 911, that's admissible. And a jury might care about that. They might say, well, the lawyer probably told him to call 911 or something like that. Why did he delay calling 911? Was his intent that this person should die? There's lots of things that can be gleaned from that. We think we understand how human beings act. Everybody thinks they got an insight. Oh, he did this because of that. Probably not true. Humans are complex. People do things for all kinds of different reasons that you might not imagine. But if no one's available to call 911, then understand they're going to ask you a bunch of questions. You know that. This is the job of the 911 operator, right? So expect that. They can't make you answer questions. You're in charge of that. 100% in charge. That's you. Hello, 911 operator. There's been a shooting. Person's down. Send the ambulance. Here's the address. Bye-bye. Click. Yes, but tell me about who shot. Tell me about... Click. That's all you got to do. You do not have to stay on the phone with 911. Now, you should know what's coming next, right? You should be prepared for what's coming next. The police are coming. They do not know whether you are a good guy or a bad guy. And their attitude is kind of like our attitude was when I served in the Marine Corps and I was in Saudi Arabia. We're coming home. That's our attitude. I can assure you that cop ain't getting shot, or at least that's the plan. They're going to shoot first before risking getting shot. So they don't know if you're a good guy or a bad guy. I recommend that you broadcast very clearly that you're a good guy, which means things like the gun should not be in your hand at the time they arrive. Maybe your hands should both be up in the air, or maybe you should be on the ground spread out. Your job now is to not be shot and killed. That's what you should be thinking about. You don't need to make any statements. You're just trying to be safe. Make it clear. Let them figure out you're the good guy pretty quick. So 911 can be an exception to the just shut up rule. Other exceptions, traffic stops. Okay, not really that concerned about a speeding ticket. I mean, I kind of am. I just got a new car yesterday and it's pretty damn fast, and speeding tickets are on my mind at the moment. But that's not really why I'm telling you just shut up. You want to try to sweet talk your way out of that speeding ticket? Have at it. By the way, I have it on good authority from a police officer that if you are a good-looking female, you are probably not going to get out of that speeding ticket. If you're not a good-looking female, they might feel bad for you and give you a break. I guess that's how one officer explained it to me. But who knows what you're dealing with there at the side of the road. But if you want to try to sweet talk your way out of a speeding ticket, have at it. My best advice, you will shock them, and I've done this on at least 5 occasions, just tell them the damn truth. They've pulled up to my window before, and I've pulled over, and I've rolled down the window, and I knew I was speeding, and I knew they had me, and I just admitted it. Yep, I was definitely speeding. They can appreciate that. I get a pass on every single one. So far, anyways. I mean, when I've employed other strategies, like just shut up. But when I've opened my mouth and just been honest with them, I've had passes each time. So that's my recommendation. You just torpedoed your trial, right? When you open your mouth and say, yeah, I was speeding. But I got news for you. You weren't going to win that trial anyways. That's a civil trial most times, and it's preponderance of the evidence, and they're going to believe the cop over you. So you're not going to win that trial anyways. Think of this as a fundraiser for the government. That's what traffic tickets are about. So anyways, if you want to, and by the way, there's a little exception to this exception. If you got a dead body in your trunk, or a whole bunch of cocaine, or some kind of illegal substance, stick with the just shut up rule. But if you know you got nothing illegal in your trunk, and you're just speeding, and you want to try to talk your way out of it, you can ignore the just shut up rule. Also, after consultation, I'm not saying you should never talk. What I'm saying is don't talk, at least not until you talk to an attorney. Why? Because I like to see what the evidence is. I like to look at the police reports. I like to see what the witness statements are. You can always make a statement. You don't have to make a statement right there at the scene. Hell, I've called press conferences on cases. Even gun cases, even high-profile gun cases. Peter Steinmetz is one of them that I can talk about because he lets me talk about it. He's the guy who brought the AR-15 to Sky Harbor Airport. Remember that? Steinmetz did the right thing, kept his big mouth shut. And by the way, Steinmetz's a great guy, one of my favorite people, another friend I made while doing criminal cases. Kept his mouth shut at the scene. Then we looked at all the video and we figured this guy didn't do anything wrong. We called a press conference. Came right out in front of my law firm. I made a statement. Steinmetz made a statement. Other people from the gun community came. We got all his charges dismissed. We even got his AR-15 returned to him. Even got a petition to clear record granted. Everything sealed up. And we made a statement. He just didn't make it at the scene. So after consultation is a great time to maybe make a statement. You have any time up to and including your trial to make a statement for the very first time. And sometimes it's fun to have the statement made right there at trial. I love springing that on the prosecutor when they have no idea what my client is going to say, and my client, after they've presented their whole case in full, says something completely different than they were expecting for the first time on the stand. Do you realize you rob your defense attorney of that joy when you make the statement at the scene? We love to spring stuff on prosecutors. Okay, number 4 exception to the just shut up rule. And I don't like this one. I'm just telling you about Arizona law. People are confused about this one. If you are detained by a police officer, which means that the police officer has determined that they have at least reasonable suspicion. They do not need probable cause to detain you. They don't need probable cause to pull you over. What they need is a lower standard of proof called reasonable suspicion. Comes out of a really famous case called Terry versus Ohio. You might check it out from the 60s, I think. And if they are detaining you because they got reasonable suspicion that you committed a crime, you are obligated to answer their question and give them your true, full name. Doesn't say you got to give them paperwork. You do have to give them a license if you're driving. But if you're not in the car, you don't have to give them a license. You got to give them your true, full name. And that's it. So that's an exception. And then this one I really hate, the concealed weapon. I think this one is unconstitutional. I wish I could challenge it. I'm looking for a case to challenge this. I have been since they passed this. But Arizona law now says that if you are detained and the officer asks you, hey, do you have a gun on you somewhere or in your car? You are now required to answer that question truthfully. If you fail to answer, it's a misdemeanor crime. If you lie, it's a misdemeanor crime. If you tell the truth, then you've complied with the statute. Why on earth do I think that this is unconstitutional? Well, because you have a right to remain silent and not incriminate yourself. Why might you be incriminating yourself here? Well, there could be lots of different reasons. One, for example, you're a prohibited possessor. You're not supposed to have a gun at all, and you happen to have a gun. Said another way, you're violating the law. And if you're required to answer that question truthfully, the law is requiring you to confess to a crime, and that's unconstitutional. Everybody understand that? So this is kind of a difficult one for me to challenge. It's not just a matter that you were asked the question. You got to be a prohibited possessor who was asked the question, and then the gun was found, and then you were charged with that crime. Now we got standing. This is now applying to you. Anyways, those are the 5 exceptions to the just shut up rule. I can't think of any other exceptions. If you want to talk to the police, it's really hard, by the way, to lay down general advice that applies to every single situation. Just know, if you're going to talk to the police, every little thing you say is going to be picked apart, and anything you fail to say is going to be picked apart, and that statement's going to be gone over and over and over, and you hope that they get down what you said accurately and that they didn't change it. So certainly, I would make sure I was being recorded if I was going to make a statement, so at least couldn't be misrepresented. Question is, if you're carrying a lot of money, that's dangerous because the cops can seize it. Anything they see, and by the way, yeah, I tend to agree with you. I've had people charged with, or not charged, but civil forfeitures brought against people for the I don't want to say crime, but for the having the audacity to carry a lot of cash. They say, well, must be a drug dealer. That must be the reason he's got so much cash. He must be up to something bad. So when they seize money, they're supposed to give you an inventory form to prove how much money was taken. But I got to tell you, I have on many occasions heard from clients, hey, the amount of money they have on the inventory form, or there's no money on the inventory form. So I unfortunately have, I don't know the facts because I wasn't there, but certainly people have told me that money has been stolen from them. So yeah, carrying cash today can be, it definitely creates some suspicion. Question is, I was pulled over for a cracked windshield, and then the first question out of his mouth, do you have a gun in the car? Am I compelled? Short answer, yes, you are. And the reason you are is because you're lawfully detained. Why are you lawfully detained? Because we had this case called the Wren case, W-H-R-E-N. I don't like this case. There was a split in the federal circuits years back. And the issue is what you might now refer to as a pretextual stop, which is, okay, the cops finding some BS little reason to pull me over. That's not exactly why they want to pull me over. They want to pull me over for something completely different. Like they just saw me leave a house that they suspect might be a house where people are selling drugs. So they watch me and they find, oh, look, he's got a crack on his windshield. We'll pull this guy over. Or his tires are bald. Or he's got a headlight out. Well, half the circuits, I don't know if it's exactly half, I'll say some of the federal circuits said, we're going to use a test called the would have test. And the would have test goes like this. Would a reasonable police officer have pulled this guy over in this situation for this reason? If the answer is yes, then this is a good stop. If the answer is no, then this is a bad stop. Okay, this probably to me makes sense as a good rule, because otherwise you got cops just hassling people. That's really the net effect. And by the way, the Ninth Circuit was in that group. Some of you don't like the Ninth Circuit. I thought the Ninth Circuit had it right there. on that split. Some of the other circuits said, no, 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 we use a could have test. Could an officer have pulled you over for this? In other words, is there any legal reason whatsoever that justifies the officer to have pulled you over? If that's the case, then that's all they need. That's the position that the United States Supreme Court adopted in the Wren case. So what the officer was thinking at the time the officer pulled you over is irrelevant for Fourth Amendment purposes. Now, they did leave the door open, by the way, just FYI, under the 14th Amendment to say, as a matter of equal protections, if they're pulling you over because you're Hispanic or you're black or whatever, something like that, not a violation of the Fourth Amendment, but might be a violation of equal protections of the law. So they left that door open. But pretty much anything else a cop is thinking, they just find a reason. And they're very clear about this now. Sometimes they say to me, I remember one cop said, Mark, I had to follow your guy for like a half a mile before I could find anything he did wrong, a reason to pull him over. And they can be bold about it because it doesn't matter what they were thinking. So that's the long-winded way of saying this was a valid traffic stop. And since it was a valid traffic stop, the officer has a right to say, do you have any guns in the car? And you are compelled to answer. Second part of that, too, if you say yes, they have a right to seize the gun for the duration of that traffic stop. They can say, okay, don't touch it, but I'm going to go in and take the gun. I'm going to hold it for the duration of the traffic stop. I think this is also unconstitutional. Something about due process, where your property is not supposed to be taken from you without due process of law. I understand this is just a gun. I understand it's just 5, 10, 15 minutes, but the Constitution doesn't say, unless it's a gun, just for a short period of time, we can take your property without due process. So I think that's also unconstitutional. It's justified the way a lot of this stuff is justified. Officer safety. Well, it makes the officer feel safer at the scene to know that there's no guns or they're in charge of the guns at the scene or something like that. I'm sure that's true. My response to that, oh well, there are downsides of being a cop. One of them is in a state where people have guns, people might have guns. Just because people have guns doesn't necessarily mean the cop is in an unsafe position. Because a lot of people, in fact, I'll venture to say most people would use that firearm to defend a cop if the cop was being attacked by a bad guy. So anyways, moving on. Self-defense. You've heard a lot about self-defense. There's a lot of statutes. If you guys have gone through the statutes, have taken any CCW courses, you probably went through them. I'm going to tell you it's all about one word, reasonableness. It's in every one of these statutes. What would a reasonable person do in this situation? That's how we judge it. All self-defense can be boiled down to this question. Or think of it like this. Imagine the trial goes as follows. Person charged with a crime, person says self-defense is my defense, and the state presents all their witnesses and evidence and everything they got. The defense then presents all their witnesses and evidence and everything they got. It's as if the judge says to the jury at this point, now, ladies and gentlemen, you've heard everything. You heard all the evidence in the case. You know everything. You've watched everything. You've heard from everyone. We need an answer from you on something. We just need to know, considering everything, did the defendant act reasonably? If he did, then he's justified. He walks out of the courtroom. If he acted unreasonably, okay, then he's not justified. That means he's guilty of the crime he's charged with. It all boils down to the word reasonable. That's it. And we try to quantify this. We have some rules that we use. For example, I'm going to tell you some of the rules where the legislature or the court has said, hey, we've predetermined what's reasonable in some circumstances. I'm going to tell you about one right now. If you're claiming self-defense and the threat against which you are trying to protect yourself or another person from is not imminent, like right now, it ain't reasonable. I'm just telling you that right away. That's why we say it's got to be an imminent threat. So if I say to you, okay, look, I've had enough of you, talking bad about my Patriots or something like that. I heard enough bashing. I can't use Tom Brady anymore because even now we bash on Tom Brady here and there. But if I say I've had enough of you, I'm going to punch you in the face tomorrow. Can you punch me now? No. Your remedy under the law is go get an order of protection. Even if I say, okay, look, here's what's going to happen. I'm going to go to the bathroom right now, and I'm going to come back and punch you in the face. Can you punch me in the face now and claim self-defense? Anybody know? The answer is no. You got to wait till I come back from the bathroom to punch me in the face. You still got to wait until I'm approaching you and I got my fist like this and I'm kind of like this. When I'm right around there, okay, now you're in business. But if you say, hey, the guy told me he's going to go to the bathroom and then punch me in the face and that's why I punched him, it's not imminent. Therefore, it's not reasonable. Therefore, you're guilty of a crime. Let me give you another one. This is one of my favorites. People screw this one up all the time. If the threat against which you are acting is just words, I don't care how offensive they are. I don't care how ugly what somebody said is. The rule is, if it's just words, it's unreasonable. You can't use self-defense to defend just against somebody's words. But as any good lawyer will point out, there's words and then there's words coupled with action, right? If somebody just stands there with their hands to the side and says, you dirty, rotten, blah, 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 you can't punch them. But if they say the same exact thing and they're approaching you and now the fist is like this and they're going back like that and they're really close to you, all right, now you're in business if they believe the facts are like that. Question is back in the first section, just shut up. This one is, I'm going to summarize and take a few liberties here. Hey, Mark, I'm in a real good shooting right here. I'm laying in my bed at night. Dude breaks into my house, shoots at me. I shot back at him, got him. Now he's dead on my living room. Cops show up. Really? Just shut up? That was your question, right? One thing I noticed you didn't mention in your question is where you shot the guy. Because those facts, you change a few little facts here and there and everything's different. Dude shoots at you. Then you come out with the gun. Dude sees you and says, wow, he's got a gun. I think I'm going to exit stage left. Turns around and starts exiting, and that's when you shoot him, and he's shot in the back, and now he's on the floor. You got a problem, right?
I don't say he broke in, I don't say nothing.
Yeah, because you got a problem in that circumstance, and I don't know the answer to that one. Maybe you don't either. Weird things happen sometimes. Maybe you missed, and it ricocheted and hit him in the back. Maybe you hit him in the side. I talked about this one on Wednesday in court this week. I was mentioning to the judge that I talk at the Crossroads of the West gun show, and I recognize there are hard cases. Like I say, Judge, inevitably somebody will ask me a question. You know, I'm home and I'm in bed and there's a guy who breaks in and then I shoot exactly like your question. And then I say, what happens when that guy turns to leave and the homeowner shoots him and it's kind of on the side? Is it a good shoot? Is it a bad shoot? I don't know. Maybe. Why? Because it's got to be imminent. If he's not facing you and coming towards you, there's a real issue about whether it's imminent. And if he's turned and he's leaving, this might be street justice. You don't get to do street justice. Plus, there can be lots of other variables here. Maybe he's in the house to steal the TV set. You don't get to shoot him to just stop him from stealing the TV set. That's another one of those rules. We're letting you know up front, you never get to use deadly physical force if all you're doing is protecting property. That's one of those rules that the legislature in Arizona has already decided. They've said it like this. We've decided that in this state, it's never reasonable to kill somebody or even to threaten to kill somebody just because they're stealing property. Now, you may not like that rule. I tend to think we could tweak that rule a little bit. Some property's really valuable. What if it's, I don't know, $100,000 or more, and somebody's worked their whole life to accumulate that amount of money? You're stealing their life's work, their labor. I don't know, maybe we should be able to use, or at least threaten to use, deadly physical force to stop that. But this is just me pontificating about what the law ought to be. That is not the law. The law in this state is no matter how valuable the property is, you don't get to use or threaten to use, which means you can't even point the firearm at somebody if it's just about protecting property. But on the other hand, again, this is why you get a good lawyer and shut up. Because while you might have said, you know, I shot him because he was stealing my expensive TV and I wanted to watch the Patriots beat the Dolphins tomorrow. And if my TV was gone, I just have to wait for the score at the end. Okay, that's going to send you to prison. But if you keep your mouth shut, maybe your lawyer says, look, I know why this guy, my client, shot him. Because after he took the TV off the wall, he was approaching and he was getting ready to hit my client over the head with the TV. And that's a threat of serious physical injury. And as you all know, you don't have to just stand by and accept the threat of serious physical injury. You can threaten deadly physical force. Well, at least most of the time. You can threaten deadly physical force. At least that's what the law says. By the way, I want to pause on this point and say something that's in my notes here. It says, you have no idea who's on your jury. Let me tell you who's on your jury. A bunch of idiots. I hate to say it like that, but I've been saying it like that for years. There's a bunch of idiots on your jury. Okay, I don't know where you are in the political spectrum. I'm just going to wild guess that probably this is not the I love Joe Biden crowd. So I will say for this crowd that there are going to be I love Joe Biden people on your jury. They're the ones who are going to be deciding whether you acted reasonably. And you got a bunch of idiots on your jury, which is why for years, I'm just going to get on my soapbox here for 1 second and say, we need professional jurors. I don't mean fancy appointed by the government. I'm just talking regular citizens who have maybe had a little bit of class, so I don't have to spend 45 minutes talking about what a presumption is, or what a burden of proof is, or about, you know, any of these various things. Because these are hard things to really get your brain around. We spend time on them in law school for months and months. We shouldn't have idiots on juries. This is another reason I recommend in the strongest possible terms, be very, very, very careful about pulling out your firearm, because you might find yourself charged with a serious crime and have a bunch of idiots on your jury. Sorry, those are the facts of life. And I'm going to get to that when I get to number 5. And the jury's going to vary by community. So if you're out way far in this state, you're going to get a bunch of rural who knows what from who knows where, who has who knows what kind of ideas in their head about things. I assure you, I talk to the jurors every time after a trial, win or lose. In both cases, win or lose, even the ones I've won, I've said, oh my God, I can't believe that's the reason. Sometimes they say things that just make me absolutely shocked, almost every time, frankly. So be very conservative. Any questions about self-defense? I want you to think about it. It's just a matter of reasonableness. Any questions about that? All right, I'm going to pick up the pace a little bit. Number 3, boy, this is a big one for today's world. If you think that what we argue about is the law, it does happen sometimes, like in the case of defensive display of a firearm. But most of the time in court, we agree on the law. That's not the problem. It's the facts. It doesn't come in like this gentleman's question here. Here's what happened. This happened, this happened, this happened, and then I shot him. The cases never go like that. What happens is my client comes in and says, Mark, here's what happened. This happened, this happened, this happened, and then I shot him. And I say, wow, that sounds like a really good case. Yeah, I'll take your case. We can argue self-defense on those facts, no problem. And then I go and meet with the prosecutor. And I say, hey, man, why are you charging my guy with this crime? Don't you know this happened, this happened, this happened, and then my guy shot him? Inevitably, the prosecutor will say to me, those aren't the facts that I got, Mark. That's not what victim is saying, victim's friends are saying, other witnesses are saying. They may be lying. They may remember things differently. They may have had a different vantage point. Humans with the best of intentions still make mistakes, right? Even on simple car accident cases. Was the light green or was the light red? You're going to get different versions. I don't know if you realize this or not, but this is exactly what's going on right now in our country and across the world with the coronavirus. We all got different facts. People aren't wearing double masks on their face because they love to wear masks on their face. They're wearing masks because they believe certain facts about the world. You might have different facts about the world. This might just be a function of what station you watch and get your news from, right? Because if you watch Fox News, well, you probably think coronavirus is, I don't know, either a hoax or something close to the flu or no big deal or overblown or whatever. But if you're watching CNN or MSNBC, you're probably more inclined to think, we're all going to die from coronavirus, the roof's on fire, hospitals are overflowing, we're all on the verge of death. I don't know where the truth is, maybe somewhere in between those two extremes. But people have different versions of facts. I never get a case where we are in agreement on the facts. Your case is going to probably turn on what version of the facts the jury adopts. That's what the case is going to turn on. And let me tell you who the most biased person in the whole courtroom is. That's you, the defendant. Because the prosecutor will always argue, all right, you can't believe the defendant. This guy's got a lot to win or lose here, right? Because it's the defendant, after all, that's going to prison here. That cop, you know, that cop's got no reason to lie. Cop's going to go home, get paid the same. And why would the victim ever lie about anything? By the way, it's really funny. In some of the more rural parts of Arizona, I used to do a lot of cases up in Yavapai County, in Camp Verde. When I was a young lawyer, I got a contract in Camp Verde. And this week, you might have this person as the defendant and that person as the victim, and then 6 months from now, they'll be reversed. Isn't it fun for me as a defense lawyer to say, wait a second, you just told me that this guy, when he was the defendant, you didn't believe a word he said. Now he's the victim, you believe everything he said, or vice versa. It's just the way prosecutors operate. But the important point here, and I don't want it to be lost, it's about what version of facts is going to be believed. And they're not likely to believe yours. That jury is going to decide the facts, and the facts are what's going to drive the case. So all of these questions where you say, hey, Mark, I'm going to give you a given, agreed upon set of facts, like your question, and I'm not picking on your question. I'm just saying a case is way different than a question. The question is, Mark, assume these facts are true. This, and this. Can I shoot him or not? I'm still going to give you kind of a wimpy answer, because I'm still going to tell you, well, it depends who's on your jury. I don't know who's on your jury. But we never get a given set of facts. We're arguing about the facts. All right, any questions about number 3, the facts? Okay, number 4, mandatory minimum sentencing. This is why probably your case ain't going to trial anyway. Takes a lot of guts to go to trial today, because almost every single gun charge is mandatory minimum sentence. What does this mean? What this means is if you're convicted, you're going to prison, in all but the very rarest of cases. But the law says that in a gun case, if you're convicted, the judge no longer has discretion to put you on probation. And the legislature knows how this works, and so do the prosecutors. They say to me, Mark, your guy's not going to roll the dice. He's looking at 25 years. Imagine we take your facts, right? In the house sleeping, and some guy comes in, and he starts shooting at you. And you get up, and you take your gun, and you shoot back at him, and you kill him. But unfortunately, just as you shot him, he started to turn and to go out the front door. He said, oh my God, this guy's actually got a gun. I'm out of here. And he turns, and it's sort of one of those where you shot him in the shoulder. And the prosecutor brings charges for first-degree murder and says, you know what, this guy was in retreat. There was nothing imminent, and he was turning and leaving. This is street justice, and I'm going to charge this guy. And the defense says, no. Look, this guy was in the house. He had already shot a gun. He was a threat. Just that he turned. It's not reasonable in the space, in the dark, at 2 o'clock in the morning to hold my guy accountable just because this guy turned. He might have been turning to grab a knife or a gun or to come at us. Who knows? This is a close call, right? I don't know what the jury's going to do. But if you guess wrong, you're going to spend 25 years in prison. Maybe you can win that case. How am I going to explain this to you? You're going to say, Mark, can I win this trial? And I'm going to say, look, man, 50-50. I might say, you got a good case. 50-50. You just never know what happens at trial. And that risk is high. So I just have, for me, I'm conservative. Very, very difficult to get me to say, yeah, in a case like that where you're looking at decades of time to recommend that you roll the dice. Most people don't. I can't tell you how many great cases I've had that should have gone to trial, that did not go to trial because the prosecutor understands this concept. The prosecutor says, okay, here's what I want you to do. Plead guilty to the lesser included. Look, I'll give you a manslaughter or something. And then you'll serve maybe like, I don't know, serve a year in jail. 1 year in jail, plead guilty to the manslaughter, check the box, another bad guy convicted, misuse of a gun, or risk your 25 years of your life at trial. Most people aren't going to take that risk. They're just not. Some have. I've had some against my advice, my strong advice, who have gone to trial, and we've won at trial. That happens too. I've had some who have gone against my advice, and the other side's dismissed the case before trial. That happens too. But because of mandatory minimum sentences, the vast majority of people are going to take the deal. So said another way, mandatory minimum sentencing deprives people of their right to a jury trial because it makes the risk of rolling the dice so high. And so that's what I said to the judge in court. There could be a circumstance like the one I laid out where someone could actually be convicted of a first-degree murder, and I would say probation should be the right answer. And the facts I just gave you. Let's make this guy no priors, no problems. Let's make him 70 years old, a good citizen. Just made a slightly bad judgment. This person doesn't need to go away for 25 years. This is a weird circumstance where someone broke into his house. It should be probation, but it won't be because the legislature has taken that away. You know why they do this, by the way? Because there's a call from the public. When the judge can give probation and does give probation, then the press says, so-and-so was convicted of first-degree murder and left-wing liberal judge gave him probation. What an outrage. We need to take this authority away from the judge. I got to tell you, I'm not in favor of that. Cases are nuanced. Different cases should be treated differently. Judges should always have discretion to give probation in a close call case, or especially a case where they say, maybe the jury got this wrong or something like that. So anyways, this is something you really got to consider and keep in mind when you're thinking about pulling out your firearm, because you're probably going to get charged with something that's going to have a mandatory minimum sentence attached to it that's going to twist your arm like this to take a plea. And you know, when you take that plea, you're going to lose your gun rights, you're going to be a convicted felon, you're probably going to do some time. There's going to be consequences. This is a horrible situation that needs correcting in our justice system. It's why I put it on my top 5 things you need to know about. Number 5, this might be the most important thing. What to think about when that moment comes. You've been carrying a firearm this whole time. What to think about when you're thinking, should I pull it out? Sometimes I tell people jokingly, I say, look, I'm available 24/7, 365. You don't have to be a member of the Attorneys on Retainer program to call us 24/7. If you are a member, you can call us 24/7. You're a client of the firm, you're represented, no problem. But even if you're not and you call us, I'm going to tell you, just shut up, right? But if you say, hey, Mark, I'm thinking about pulling out my firearm, can I? I might humor you. It might be 2 o'clock in the morning, I can't sleep or something. I'm going to say, all right, tell me about that circumstance. I need to know, who are you? What's your background? What's your weight and size and training, by the way? And tell me about the threat. How far is the threat? What's going on? Do they have any weapons? Do you have other options? Who's around? I need to know lots of different things. So we're going to need about an hour to go through this circumstance. And then at the end of the hour, I'll probably be able to say in a very conservative kind of way, you know, seems like it's a good, assuming you're telling me everything that's relevant and there's no other facts that I don't know about and blah, blah, blah. Maybe you can pull out your firearm or maybe you can't. Does anybody see a problem with this circumstance? I'm going to take this as the answer is yeah, there's a huge problem here. If you got an hour to talk to me about the threat, this is not imminent, right? Period. So if we're even in the ball game here for legitimate use of self-defense, you got no time to talk to me, period. You got to make a decision right now. Here's the Marc Victor analysis for whether you should whip out the firearm. I want you to think, if I pull out my firearm right now, I'm going to be charged. Now, let me explain what charged means. I want you, and I'm not saying this is going to happen in every case, but this is what I want in your head. When those cops show up, they're going to assume I'm the bad guy. They're going to, as they say in the police reports, escort me to the ground. I don't know if you've ever been escorted to the ground before. Excuse me, Mr. So-and-so, this is the ground. Would you like an escort to the ground? We escort you to the ground. That's not exactly how it goes. Imagine your face is going to be smashed into the pavement. You are going to become one with the earth. And then you're going to be handcuffed, and they're going to be uncomfortable, and they're going to throw you in a jail cell. And you think you're going to explain this to the judge, but the judge has already read something called a Form 4, which is the officer's version of what happened. And it's not going to put you in the best light. And imagine that judicial officer who's going to consider your release conditions, which is required to happen within 24 hours, by the way, in Arizona, is going to set a really high bond, maybe cash only. It's going to be really hard for you to post it. And you're going to be charged with, let's just say, the most common crime, aggravated assault when you pull out your firearm, a dangerous Class 3 felony, 5 to 15 years. And then you're going to go through a miserable year where when you wake up in the morning, this is what you think about. And when you go to bed at night, this is what you think about. And stuff that used to be fun isn't as much fun anymore because this is hanging over your head. I know what that's like, by the way, because I've been charged with aggravated assault before. While I was a lawyer, while I was a criminal defense lawyer, by the way. I went through a BS prosecution myself, got arrested, thrown in jail, treated like crap. I had the experience of being a defendant. Maybe most importantly for me, I had the really enlightening experience of having somebody pound on my cell and say to me, "Your lawyer's here." And I was taken out of the bowels of the hellhole that I was in and brought to a little window to talk to someone on the outside who cared something about me. I can't tell you what that felt like. I remember that every single time I go to the jail now to meet with a client. I know what that's like. And by the way, if you want to hear about the full story of what happened to me, it's on our YouTube channel. I think it's just what I learned from liars and Neanderthals. I highly recommend you get the story of my experience because I had an experience being on the other side of the desk. And I wasn't exactly thrilled with my criminal defense lawyer, but how it turned out, you'll get to see. But I want you to imagine you're going to go through this miserable experience. And unless you're a member of the Attorneys on Retainer program and you got the self-protection plan for $25 a month, you're going to be looking at about $100,000 in legal fees to fight this thing if you decide to fight it. And how much did you want to spend in legal fees? I know, $0. That's how much you wanted to spend in legal fees, but you're going to have to spend it if you want to have any kind of a defense. You're going to have a long, stressful experience, and then your lawyer's going to tell you about a mandatory minimum sentence that you're faced with, and you're probably going to take a deal. And I know what this is like because I've stood next to people who have reluctantly said, "You know what, Mark, I'd love to take the case to trial, but I'm not taking the risk of going away. And the prosecutor just offered me this deal." And now you're going to be one of the stats of another person who used a firearm to commit a crime for the Joe Biden crowd to say, "Look, here's why we need to ban guns, because more bad guys use them to commit bad crimes." You're going to add to the numbers of people in that crowd. You're going to have a miserable experience. And then at the end of that, you're going to lose your right to possess firearms anyway. Because when you become a convicted felon, even when you get charged with the crime, you lose your right to keep and bear arms right then and there. That's a pretty miserable experience, right? I want you to keep that miserable experience in your head. And now let's go back to the split second you have. I'm thinking about pulling it out. Here's what I want you to think about. If what's going to happen to me right now is worse than that miserable experience, then pull out the firearm. If the miserable experience seems worse than what's going on in my life right now, do not pull out your firearm. Okay, so I want to give you some, this is like the quiz at the end of the chapter, quiz on how we apply the Marc Victor analysis here to figure out if you should pull out your firearm. Okay, so here's the situation. If you don't pull out your firearm right now, you're going to be dead. Okay? Putting aside questions of what happens after you're dead for a moment, let's assume that's pretty bad. Dead is bad. Being prosecuted, as I have listed it out, well, that's bad too. We want to avoid that. Which seems worse? I think dead is worse. And since dead is worse than prosecuted, I'm going to pull out the firearm. Everybody see how that analysis worked? Okay, little bit harder one right now. If I don't pull out my firearm right now, somebody I love or like a lot is going to be dead. Okay, prosecuted, that's still bad. I don't want to go through that. But I don't want someone I love or even like a lot to be dead. I think I'd rather be prosecuted. So pull it out. Everyone understand that? Okay, now here comes an example from my practice. Actually, a case that I had. Had a guy came in my office charged with the ever popular aggravated assault, dangerous, class 3, 5 to 15. He pulled out his firearm, pointed it at somebody, got charged with the ag assault, because that's how you get charged with ag assault, by the way. Pulling out your firearm and pointing it at somebody. No, you don't have to touch anybody to actually commit an assault. And if you scare somebody with a gun and you're not justified, that's an aggravated assault, right? Everybody see that? People come in my office all the time and say, hey, Mark, I'm charged with assault. It's going to be such an easy case. And I say, why is that? I never even touched the guy. Ha ha. And I say, well, you're not going to like what I have to tell you, but you know you can commit an assault without ever touching somebody. An assault is scaring somebody in a way, intending to put them in fear of an imminent physical injury. If you do that with a firearm, then you've committed an aggravated assault. So the guy in my practice did exactly that. And I said to him, why did you pull out your firearm? In the context of an attorney-client meeting. You know what he told me? Because I was being disrespected. He said, I pulled through the drive-through window to pick up whatever it was he ordered, and he didn't like something about the person at the window and felt that they were disrespecting him. And he wasn't going to have that, so he pulled out his firearm. Okay, let's give this guy a fair shake. Let's analyze his situation. Nobody likes being disrespected, right? Anybody here like being disrespected? Let's just say that's a bad thing. Being disrespected is a bad thing. But being prosecuted, as I've just described it, which do you think is worse? I don't know. I'm kind of like disrespect the hell out of me all day long rather than prosecute me. So there's one where we can say, do not pull out the firearm. Everybody understand that? Maybe some other examples here. Somebody is going to slap you in the face. Would you rather be prosecuted or slapped in the face? I'd rather be slapped in the face. I'd rather be punched in the face. I'd rather have property stolen from me. I don't want to be prosecuted, and neither do you. What am I getting at here? Why does Bob Templeton, the owner of the Crossroads of the West gun show, want Marc Victor speaking about rights and responsibilities of gun owners? Because I'm going to tell you how it is. If you're excited about pulling out your firearm, if you're one of those people who just can't wait for the time to come to pull out your firearm and point it at somebody, you should not be carrying a gun. I'm very conservative. So should you be if you value your liberty. Well, Arizona is a very pro-gun state. It's also a very pro-prosecution state. you are definitely going to be prosecuted aggressively here. They're pro-gun, but they are not pro-gun crime. The question, does a prosecutor ever drop a case? The answer, yes. I've had several gun cases dropped. I'll tell you about one. I had some scrambled egg on my face. I had a case, my guy pulled out a gun, pointed it at someone, got charged with a Class 3 ag assault. I thought we had a good defense. It's another one I took over from another lawyer. We took it over, we got a better plea. It was a 6 open, which is a really good plea. It can turn into a misdemeanor. I said, victory, this is much better than the other guy got for you. They didn't want to try the case. He said, I'm not taking that 6 open. I said, are you kidding me? It's going to turn into a misdemeanor. Nope, not taking the 6 open. So we talked about it. I couldn't talk him into it. I went back to the prosecutor and said, nope, he wants to go to trial. Prosecutor came back and said, fine, I'll give you a misdemeanor, straight misdemeanor, pay $200 fine, out the door. I said, all right, thanks, man. I went back to call my client in for the meeting. Said, good news, case is over. Plead to a misdemeanor, assault, $200 fine, out the door. I said, I didn't do anything wrong. I'm not taking the deal. I'm going to trial. I'm going to risk 5 to 15 years. I said, dude, you can't. Called in all the other lawyers at the firm. Hey, let's stop this guy from making a bad decision. It's way too much risk. At the end of the day, nope. I'm going to trial. I did nothing wrong. Went back to the prosecutor, said, all right, we got to pull a jury, Class 3 dangerous ag assault. Dismissed the case. They don't want to lose. They should never lose. I laugh when I hear these prosecutors say, I've won 90-something% of my... Of course you've won them, because anything that looks good for me, you dismiss most of the time. They don't usually go on hard cases. All right, any questions about how to apply the Marc Victor analysis in terms of whether you should pull out your firearm? I think that was the long-winded way of saying, if you can avoid pulling that gun, you should definitely avoid pulling that gun. I'm just telling you, let life go on, right? Interestingly enough, I've taken the bar exam about 2 or 3 years ago. I've been practicing 27 years now. So after about 25 years of practice, I took the bar to get into Hawaii. We now have a law firm in Honolulu. Hawaii's gun climate is the opposite of Arizona's gun climate. Hawaii has a completely different rule. Hawaii, you have a duty to retreat. Everyone in Arizona loves, oh, no duty to retreat, castle doctrine and stand your ground and all that great stuff. And it's true. In Arizona, you have no legal duty to retreat. In Hawaii, if you can retreat in complete safety, you must. Sounds like a totally different rule. But you know, it's caused me to think about the differences between the two rules. If you can retreat in complete safety, it must not really be an imminent threat. I have trouble figuring out the difference of when you would... In fact, I had lunch with Bill Montgomery not too long ago, and some of you may know Bill. We started out as adversaries. He used to be the Maricopa County attorney, and I met him when I showed up to debate legalized marijuana. He was on the other side, and I never met the guy before. And we had several debates. You can still find him if you go to Google and just Google Marc Victor, Bill Montgomery. Bill's now on the Supreme Court in Arizona. He's a Supreme Court justice. We had lunch, and I was talking to him about the difference between the rules in Arizona and the rules in Hawaii. And both of us think that while they're written dramatically different, at the end of the day, they're not really so different. Because if you can actually retreat in complete safety here, it's hard to imagine how you might still have an imminent threat such that you're required to pull out your firearm and use deadly physical force. In fact, one thing I thought was interesting in the commentary on Hawaii's rules, because you might very quickly dismiss that rule and say, we don't like to retreat here in Arizona. But in Hawaii, they basically, and I'm paraphrasing here, they say, look, we recognize that this is sort of a, you might be considered a wimp or something, having to retreat. We don't, we recognize this and we acknowledge that you have to retreat. It gives a certain, I'll just say un-American type of an attitude here. But they go on and they say, but we value human life to the point that if you can retreat in complete safety, we'd rather save the life. I gotta say, that's sort of a compelling argument to me, especially in the case that I don't think the rules are all that different. I'm not taking a position on which rule. I'm just saying there are different approaches to the rules here. But in either case, you're going to be charged with a very serious crime if you pull out your firearm 9 times out of 10. Now that I've finished saying that, I have had several examples, by the way, in my career where people did pull out firearms, pull the trigger, shoot, kill another human being, and they did not get charged. So I don't want to overstate the case. I'm not saying you're always going to get charged. But if you're not willing to be prosecuted, I don't think it's a serious enough situation. You should be willing to be prosecuted, which really leaves on the table, you're either going to be dead, someone else is going to be dead, or you're going to suffer a very serious physical injury. If you're in that kind of a situation, I'd rather be prosecuted too than to suffer that kind of either death or serious physical injury. All right, so any questions about number 5, most important thing you need to know? By the way, if you have questions anytime, on topic, off topic, happy to talk to you about anything that I'm talking about here today, anything in criminal law, anything in the criminal justice system, anything in the Constitution, or anything in the most important project happening in the world right now.